Well, welcome everybody to today's webinar hosted by the National Agricultural Law Center. Of course, we're the nation's leading source of agricultural and food law research and information. If you're not familiar with us already, I'd encourage you to visit our website, click around and learn some more about the type of work that we do for the ag industry and the ag community throughout the United States. I'll introduce our guest today in just a moment in more detail, Judge Stephen Vaden, Deputy Secretary Stephen Vaden. But first, uh, Rusty, can you move to the next slide? Just a couple of housekeeping matters. There'll be a QR code here on the screen in just a moment. For those of you who are interested, this is one of our items that we publish. This is a newsletter that comes out pretty much, well, every 2 weeks throughout the year. In December, we do just one. But it's a quick rundown of ag and food law issues, everything from proposed regulations, final rules, enactments, proposed noteworthy proposals at the state and federal level, you name it, along with a brief description of the issue and links to resources if you want to take a deeper dive. And then next slide, please. For those of you who are interested, we will host our 13th annual Mid-South Agricultural and Environmental Law Conference in Memphis, Tennessee, again this year on June 4th and 5th. And Judge Vaden will be our keynote speaker for that. It's a great program. We also live stream it for those of you who are unable to make it in person, but it's a great event. We're lucky to be doing it for 13 years. And I just want to make sure I mention that and invite all of you to check it out. And we have the agenda up on our website, and registration will be up in the next 2 or 3 days. And we partner with the National Association of State Departments of Agriculture Foundation on that particular conference, along with other partnerships we have. All right, it's my pleasure and my honor to introduce a great friend to the National Agricultural Law Center and someone with a really unique background in the government, Judge Stephen Vaden. I hope it's okay if I still call you Judge. I go back and forth from Deputy Secretary to Judge.
I won't object.
All right. So Judge Vaden he's from Union City, Tennessee. And he has, as I've mentioned, a very unique background from serving in private practice, but also as general counsel. He served in the federal judiciary, in the Court of International Trade, and now Deputy Secretary for USDA. He was appointed by President Donald J. Trump, confirmed by the United States Senate in these roles that I just mentioned, and in his current role oversees more than 250 legal professionals and legal matters for a department of over 100,000 employees and a budget that approaches $150 billion annually. And we'll talk about some of those, some of the budget today in terms of bridge payments and the like. During his time at USDA, USDA has prevailed in 2 United States Supreme Court cases, carried out a variety of regulatory reform initiatives, implemented the 2018 Farm Bill, now, as we'll discuss a little bit today, implementing the One Big Beautiful Bill Act provisions that relate to agriculture. Relocated and reorganized key agencies, which is an ongoing process as well, currently with the USDA reorganization. Been very involved in hemp issues and a host of other matters, bioengineered food disclosure, just to name a few. So with that, I'd like to pause and let's just kind of jump into it. How about that?
Sounds good.
So I'm just going to, as we go through this, I'm not a professional interviewer or anything like that, so I'll prepare our audience, but for that reality. So we'll go through a number of areas that, that I think are pretty important, that I hear from people in the ag industry. Before I do that, kind of a little bit of a background. I should have mentioned in the housekeeping, you'll see a poll pop up. Those of you in attendance, just fill that out. It's common sense, and we use that to help improve what we do, and your input's very helpful. So I want to talk a little bit just about background, then we'll move into some substantive issues. But as I've mentioned, you served as general counsel and now as deputy secretary, and in between, a member of the judiciary branch, particularly the general counsel's position, but also as a federal judge. How does that how does that factor in? The thing that jumps out to me is general counsel oversees everything in a sense, like all missionaries, every involvement at USDA, as does the deputy secretary position. That's a very unique sort of bookend, if you will, within USDA. So I'm just interested if you could speak to that a little bit.
Well, you've hit it. USDA is a very large cabinet department. I know your audience is probably well aware of this, but the average citizen probably doesn't understand that we have 8 undersecretaries. And when I go talk to my counterparts at most cabinet departments, they just have 2 or 3, if that. And each of those undersecretaries oversees a small part of what USDA does every day. By contrast, the secretary, the deputy secretary, and the general counsel are the 3 officials who have to see the entire picture, obviously from different perspectives, but they know what all 8 areas are doing, and it's their responsibility to keep the trains running in all 8 areas. And so being general counsel of this department in the first term was incredibly useful because I got to know each mission area. I got to understand the issues that bubble up. And obviously, though I was looking at them from a legal perspective, part of that includes understanding the policies and the policy choices that our political officials have and being able to lay out where they have room to make those choices within the confines of the statutes that govern them. So transitioning to deputy secretary from general counsel, the one thing that I had to dispense with is I could no longer say if I didn't want to opine on an issue, oh, that's a policy matter. I'm just a lawyer. Sorry. So I can't say that anymore. Now I am a policy official and I do have to opine on those matters. I also think being involved in the federal judiciary was helpful because, I've seen it from both sides, from the agency side in terms of promulgating a regulation, and from the court side in terms of what it's looking for in terms of ensuring that a regulation has been properly promulgated, that its record supports it, and the level of responsiveness you want from an agency. So those 2 sides of the equation, particularly in our contentious times where almost everything of substance any agency does winds up in the federal courts, are helpful experience to have for anyone in this position.
All right, thank you for that. So speaking of statutes, the One Big Beautiful Bill Act, which was of course wide-ranging, involved had a lot of provisions that didn't directly pertain to the ag industry, but there was a lot in there, probably more than we can really unpack here. But can you speak to, particularly on the bridge payments and the farm program side, given the financial strife that everybody's well aware of, particularly in the row crop industry, but where USDA is in terms of the status of that and implementation, the process, and of course anything else that you think beyond even the bridge payments it's worthy of mentioning here.
So you've laid out quite a lot there. I'm going to start with talking about the One Big Beautiful Bill Act, the changes that it made, and then I'll talk about why I I think I may have been the first person to refer to them as a need for a bridge to get us from where we are now to all of the provisions of the One Big Beautiful Bill Act, which kick in the fall of this year. So the One Big Beautiful Bill Act, given the nomenclature where people are talking about Farm Bill 1.0 or a skinny farm bill, it's probably accurate to call the One Big Beautiful Bill Act. It would be Farm Bill 1.0 or the Fat Farm Bill, because there was so much agricultural policy fit in there. And for those involved in production agriculture and those lawyers who advise them, some of the key changes are making provisions that had heretofore been temporary permanent, particularly when it comes to tax law. Those heretofore temporary positions that allowed farmers to immediately expense, for example, when they purchased a new tractor, when they put up a new silo for grain storage on their farm, those are now permanent law. And the amounts that you can immediately deduct have been increased to $2.5 million. We've gotten rid of the estate tax, which is a huge issue for so many people who own farmland, for 99.9% of all estates. We have taken the exemption, we have raised it, we have made raising it permanent, and we have indexed it to inflation so that more and more people aren't brought into the estate tax over time, simply because of a rise in the cost of living. And so that's going to make estate planning for so many of our family farmers, again, on a permanent basis with no expiration date, much easier. It also, for the first time in a long time, updated reference prices and updated crop insurance. So that now, for the first time, quite frankly, probably since 2018 or 2019, our ARC and PLC programs will accurately reflect the increased cost of production that farmers have seen throughout the past several years. And we have made it easier to get crop insurance, and we have increased the subsidy to encourage people to get crop insurance so that they can hedge the risk and make certain that there's easier financial stability for their operation. In addition, producers for this year who are waiting for their ARC PLC payments, which will come in October of this year, they're not going to have to worry about electing ARC or PLC. I cannot be involved in production agriculture in this role as deputy secretary, but prior to this, when I was and working with my brother, maybe your audience is wiser than we are, but we always pick the wrong one. If we picked ARC, it was PLC that we should have picked, and vice versa. This year, producers aren't going to have to worry about that because we at USDA are going to do the math for them. And whatever program would pay their operation the most, that's what they'll get automatically. And so all of that is going to kick in full in October of this year. That explains why we needed the bridge payment program, because we've just completed the 25 crop year. Farmers are sitting down with their business managers, their bankers, family members, and they're determining how is it going to look for this next growing season in calendar year 26, and how are we going to maintain the finances that we need in order to get there. And so given the realities of increased input costs, as well as commodity prices not where we want them, we set aside a total of $12 billion from the Commodity Credit Corporation to provide in the form of bridge payments. 11 billion of that 12 billion will go to the large commodity crop farmers. 1 billion has been set aside to be split between sugar producers and specialty crops. For the $11 billion that we have set aside for row crops, we intend to make the program function, as far as the producers are concerned, a lot like ECAP, the Emergency Commodity Assistance Program, which we rolled out and implemented in 2025. So what that means is that currently our team at the Farm Service Agency is hard at work pre-filling out forms for all of the eligible producers based on the information they filed with the Farm Service Agency in crop year 2025. Those should be ready next month. And when a producer comes to their FSA office to sign up, all they will need to do is look at that pre-filled out form and confirm the information listed on it is correct. Assuming that it is, they need only take out a pen, sign their name at the bottom of the page, and return it to our USDA employee. Once they've done that, they're finished. And a couple business days later, just like with ECAP, they'll receive a direct deposit to their checking account with the bridge payment included. And so we're trying to make it as easy as possible and doing all the work up front for our farmers so that all they need to do is sign their name and then wait a few days to see the check directly deposited into their checking account. We also published, as you know, Harrison, on the 31st of December, what the payment rate should be. So every farmer can go to the USDA website, look at each of the crops listed for the 11 billion portion that go to row crops. They can see how much the payment rate is. They can multiply that by their production last year, and both they and their banker can have certainty as to the amount of money that will be reaching their checking account by the end of February. And that will help their banker make certain that their cash flow situation is accurately reported and considered as they make lending decisions for the operating loans necessary to get the 26 crop in the ground.
All right. And then payment limitations is the new limits. How do those factor in here?
Well, we made the decision with the bridge payments to have the payment limitations apply. And the reason why we did that, it was a policy call, and it was made for the following two reasons. Number one, we have a limited set of money. The Commodity Credit Corporation is a definitive pool, And obviously, a large part of it is already spoken for because it funds the normal Farm Bill programs like ARC, PLC, and the wonderful conservation programs run by the Natural Resources Conservation Service. So there was a definitive and limited pool from which we could draw. Secondly, the data that we have reviewed tends to show that while for row crops, obviously it's across the board, the prices are lower than farmers need them to be, and input costs are higher than they should be. When you looked at smaller operations, they were disproportionately suffering harm from this combination of squeezing from both sides of the balance sheet. So having a limited pool of money and having data that showed that smaller producers who obviously would come in under the payment limits with regard to their gross income and other calculations, we made the decision to apply the payment limits so that to the extent we were showing any bias, we were showing bias in favor of those producers that the data showed were disproportionately suffering the worst from this combination of circumstances.
All right, appreciate that. Well, let's see, USDA reorganization. That's been a big and ongoing issue. And I bet you currently know more about where it's at than maybe it's been able to be published and read about so far. So I'll just kind of throw that out there in the most general way I know how. Sort of where are we at with it, what comes next, what to expect, and so forth.
Well, first of all, you do a great job, Harrison, with your own website of putting information out there for agricultural practitioners in the law and those who are actually farming that they can go to and understand. We've tried to emulate what you're doing here at USDA by creating our own reorganization website, usda.gov/reorg. Anyone who is interested in the historical documents that lays out what our plans are or future announcements, check that website regularly because that's where we will continue to deposit decisions, information, and documents for the public at large. Basically, we've got a situation where we have a footprint here in Washington, D.C. that calling it underused would be diplomatic. The South building that is immediately behind me can seat, if it were fully occupied, nearly 7,500 employees. On its busiest day in this administration, and keep in mind that we in the Trump administration require everyone to come into the office. There's no large-scale teleworking going on. That building has never even reached 40% occupancy. That means on a standard day, more than 60% of that huge building is unoccupied. And when you add on top of that there is, with that one building, more than $1 billion in backlog maintenance, you begin to get a picture of what we have at all of our facilities here at USDA. Because the sad fact is, none of our current facilities, none of them, have an occupancy rate that touches 60%. And when you add in the backlog maintenance from all of our Washington, D.C. facilities, it's $2.2 billion. So whether you're a businessman looking at this situation, or whether you're looking at it from the sense of properly managing the taxpayer money, which is harder and harder to come by, it makes no sense for us to have $2.2 billion worth of backlog maintenance in keeping up facilities that are largely empty. We need to shrink our footprint. We need to make our footprint match our actual needs and let the rest go. In addition, the cost of living continues to be an issue, particularly here in Washington, D.C. And government salaries, out of necessity, can only go so high. So we have a great crop of employees here at USDA. Many of them have given years, if not decades, of service and experience to the American farmer. We need to ensure that the next generation of USDA employees has the same ability to stay with us for years and even decades so that the American farmer and the American taxpayer can take advantage of their accumulated expertise. And we're in a city right now that on a government salary, it is exceedingly common if you want to have a house with any size yard for your family on a government salary, you're looking at a commute one way each day approaching 1 hour or more. It is not unheard of. I mean, you know, Harrison, there are people who commute into Washington, D.C. from the eastern panhandle of West Virginia, which is more than 70 miles away. That could be a 2 hour commute. We've got people here at USDA who do that. How many 20 something and 30 somethings that we need to attract to be the next generation of ag experts at this agency do you think are going to want to do that for 5, 10, or more years? All the while the cost of living continues to increase in this urban environment. The answer is not many. And yet we have a footprint located across this country where we've already got concentrations of USDA employees located in cities that are easy to get to by air, have commutes for our employees who are already there of 20 minutes or less, and they commute to a home with a yard, and a cost of living that makes it possible to afford all that on a government salary. So when we're looking toward the future of USDA, there's really no choice when you combine shrinking budgets, increasing cost of living in Washington, D.C. is one of the most expensive places to live in the United States, and the needs of a department that is focused not on urban America, but rural America. It makes the most sense to get the largest number of our employees to places where they can have the quality of life that they deserve on a government salary, and we at USDA can take advantage of their expertise for decades in the future and have them in places that are actually closer to the communities we are charged with serving. So we laid out that vision last year. This year, we're going to implement it. One of the first things that I did as Deputy Secretary on returning after Christmas was sign a memorandum authorizing our department's Assistant Secretary for Administration to begin to enter into leases for the new facilities that I have toured that USDA will expand in. All of the facilities that we are expanding in are already government owned or government leased. They just happen to be unoccupied or underused, kind of like our facilities here, except they are much newer, technologically adept, and ready for us to move into at not only no additional cost to the taxpayer, because the taxpayer is already paying for these facilities because the government already owns or leases them, but at less cost to the taxpayer because they don't have the $2.2 billion of backlog maintenance that we have here in Washington, D.C. So as we go forward this calendar year, you will see further announcements of leases that we are entering into. You will see us delivering notices to those employees whom we will request to move to the new hub locations. And we are taking into account for our employees the fact that many of them have children in school. So we anticipate the moves will take place after the school year ends this school year and before the new school year begins in their new locations so that they can move during the summer and be settled by the time the school year begins and their children can go to school in their new schools in the fall of this year. So that's the timeline we're working on. We're keeping our employees in mind, all while trying to ensure the future of this department and its ability to hire the best for as many years as they're willing to give us.
All right, thank you for that. So another major area, along with USDA reorg and the One Big Beautiful Bill Act, and of course the bridge payments we've discussed, in general trade, international trade, and obviously that includes in large part, an important part, agricultural trade. And it's obviously a major focus for the administration. World of tariffs, we got Supreme Court litigation with tariffs, a decision at some point to be issued. So I'll throw that out in a general way too. Like, where are we on trade agreements, on the trade picture, soybean purchases, so the commitment with China, what's the latest with that? And I'll just kind of throw in there, two of the names that come up a lot are Brazil, China. How do you see that picture? And we'll see where that goes. I may throw in a question about Maduro in a moment. We'll just see. But I'll just throw that your way.
Well, you've got a lot there. We've got a limited amount of time, but I will try to focus the conversation here. I think it's important to remember where we were. This is the 21st of January. We've just crossed the 1 year mark into the president's second term. So when the president came into office on the 20th of January, 2025, it's important not to forget where we were. It was the policy of the previous administration that they weren't interested in new trade agreements. That is to say, even if a country came to the United States and said, we'd really like to negotiate a new trade agreement with you, as the United Kingdom did, for example, their answer was no, we're not interested. So there were no new trade agreements, no new markets open for American agriculture for 4+ years. On top of that, you had not only trade stasis, you had policy stasis. Because a fact for your listeners, Harrison, if you go all the way back to 1933, so in other words, to Franklin Roosevelt's first term as president, every person to have held the office of the presidency, except for two, can say the same thing. They signed a farm bill. The two that did not sign a farm bill were Gerald Ford, who served a truncated 2.5-year term following Richard Nixon's resignation, and our previous president, Joe Biden. So, to put it more accurately, Joe Biden is the only president who served an entire 4-year term in modern American history who didn't sign a farm bill. So for American agriculture, for 4+ years, you had no new markets being opened and no new farm bill and trade policy. And it doesn't matter whether we're talking about agriculture or whether we're talking about manufacturing or whether we're talking about the service sector. If you spend 4 years treading water and not innovating and not growing and not progressing, you're going to fall behind. And that's what's happened. And even more unfortunate for our American farmers is while we were taking a vacation, our competitors were not. And you hit on the most important competitor. That's Brazil. They have been steadily, reliably, and unceasingly increasing their agricultural footprint. Whether we're talking about corn, soy, sugar, cotton, and for the first time ever, last year, they exceeded our production in beef. They have been taking our market share and challenging us for our customers. And so whenever someone wants to talk about China, I understand that, but it's important to remember China is the symptom, it's not the cause. If we were to go back 10 years ago and we had the same policy we do now, the Chinese would still have would be in a much worse situation in that they would have to buy from us. There was no other supplier that could meet the level of commodities that they needed to purchase. Thanks to the unceasing growth of Brazilian agriculture, largely at the cost of burning down the Amazon rainforest, it's important to know, the Chinese now have a choice about from whom they buy, and they are exercising that choice. And what's more, when we look further into the future, Harrison, we know the Chinese would ultimately like to be self-sufficient. They would like to rely on both Brazil and the United States less for commodities and have more of them grown by Chinese, or not if Chinese, the near abroad to them, Russian farmers in the Far East. All of that paints a picture of a situation in which if you're dependent on only one customer or one primary customer to purchase whatever it is you're selling, agricultural commodities especially, you're in trouble. And that's where we found ourselves on the 20th of January, 2025, largely dependent on one customer who now had a choice about where it chose to make its agricultural purchases, all the while having done nothing to open up new trade markets. So that's why this administration has pivoted to focusing on stabilizing trade with China, which is important. That's why you have that baseline agreement to purchase at a minimum 12 million metric tons of soybeans this marketing year and 25 million metric tons of soybeans for each of the next 3 marketing years. Update for your listeners, China's more than 80% of the way toward meeting that, and the marketing year has yet to end for 25-26. We expect them to meet the 12 million metric ton goal and move on to the 25 million metric ton for each of the next succeeding 3 years. So they're on the path to meeting their commitments, which is important. But we've got to open up more markets in other countries so our farmers have more places to sell. And anytime you are starting from a complete stop, which is where we found ourselves, 4 years worth of stoppage in January of 2025, it's going to take some time to get up to speed. But that's why I was happy that as we got into the third and fourth quarters of last calendar year, we began to see new trade agreements and new trade frameworks with Southeast Asia, Japan, and countries in the Western Hemisphere. Many of the barriers we were knocking down were not tariff related, because as is so often the case in agriculture, they're non-tariff barriers, like phytosanitary concerns, which have no scientific backing, or the European Union's effort to use geographic indicators to box out American farmers' products from being able to compete on an even playing field in foreign countries. It's one of the most underreported aspects of the trade agreements that have been reached thus far, Harrison. That's why I want to emphasize that really for the first time in decades, we have successfully knocked down in countries like Indonesia, in countries like Argentina, the European Union's efforts to say, if it doesn't come from the EU, you can't call it Parmesan cheese. If it doesn't come from France, you can't call it champagne. If it doesn't come from one of our countries, you can't call it Asiago, and the many other names which are common names in trade that everyone understands, and yet they want to trademark because their original origin happened to be a European country. And so as these barriers fall, and as this administration continues to work to open up new markets, farmers will have more places to sell than just one country, which, given the market dynamics, is critical. Now, on top of that, I would be remiss if I did not mention that we need a proper biofuel policy to open up domestic demand. The Secretary has endorsed E15. She did so most recently at the Farm Bureau convention out in California. We need Congress to pass that. That's going to instantly result in at least 50% more corn usage for ethanol, meaning millions of more bushels will need to be purchased from American farmers to meet that increased biofuel demand. We've got a great partner in Administrator Lee Zeldin and his team at the Environmental Protection Agency. They've got a proposed rule out now, the RVO rule, which looks at blending requirements for both ethanol and biodiesel going across the next couple of years. The targets that they have set are aggressive, some of the most aggressive that have ever been set. But what's equally critical is that for the first time, the EPA is proposing to make those targeted numbers, which make the headlines, real. Because they're proposing, again, for the first time ever, to reallocate volumes that have been waived through the small refinery waiver exemption. The courts have interpreted that exemption. They've tied EPA's hands and say, if a small refiner which meets the following criteria, which the courts have defined, and they've defined both small refiner and the criteria, EPA has no discretion, essentially, other than to grant the waiver. What has historically happened are those waived volumes of biofuels that those small refiners could have blended essentially drop out of the equation. No one ever produces them. No one ever blends them into our petroleum fuels. And so the bushels of corn and soybeans that are necessary to create those biofuels are never purchased, depressing the price. What the EPA has proposed is simple. Okay, fine. If you're entitled to small refinery waiver, you'll still get it. But we're going to take those volumes that you would have blended, and we're not going to allow them to fall out of the system. Instead, we're going to reallocate them to the larger refiners, which are subject to the blending requirements, and they're going to have to blend those amounts on top of their normal requirements. So the volume will not fall out. Those bushels of corn and soy will end up being purchased, and farmers will see the benefit. For the first time ever, that top line number, which gets so much attention as to how many gallons of biofuels we need to blend, it'll be true. And that's saying something, and that will make a difference.
All right. Um, I want to shift gears a little bit into the world of pesticides, and particularly FIFRA preemption, Federal Insecticide, Fungicide, or Rodenticide Act. Has been for many years. That's been an ongoing issue. In recent years, we've seen the proliferation of civil lawsuits, and we've had a split in the circuits between the Ninth Circuit, the 11th Circuit, and then they both ruled that FIFRA did not preempt certain state law claims, particularly state law failure to warn claims. Then the Third Circuit has issued a ruling with the other direction on that, and that FIFRA did preempt. And now we've gone through a process of over the last several months to a year, the Supreme Court sort of entertained the idea of whether to take the case up, and then things happen so quickly. I really think it's been in the last 6 or 7 days. It's been pretty recently. The Supreme
That's
Court
right.
announced that they're going to take that case. And at least in my estimation, I personally rank that issue as really one of the, if not the top, it's certainly top 2, 3 issue looking out over the next years or generation of American agricultural production. And so curious, any insight, thought you have? I know the administration has taken an official viewpoint here. And anything you could add about FIFRA and where the Supreme Court's headed, and from a USDA perspective and administration perspective, what you think?
Well, first, I want to say something that as a lawyer myself, I know lawyers don't hear much, and that's thank you to the team at the Department of Justice, because as you noted, they filed a brief recommending the Supreme Court take this case to resolve the circuit conflict, and they came in on the side of American farmers. They said American farmers need Roundup and other chemicals in order to grow what not only the United States, but the rest of the world eats every day on their plate. And federal law is clear. EPA regulates what goes on every chemical label. 12 people on a jury in specially selected judicial hellholes that trial lawyers know so well don't get to regulate it. And that is the genesis of this whole issue. We have the EPA relying on decades and decades of scientific study, which shows that the label that they have approved is sufficient to tell farmers how to use the product without harming themselves or the environment or anyone else. And we have that being second guessed by juries located in jurisdictions specially selected by trial lawyers who know where there is a jury pool that is more than willing to engage in jackpot justice and listen to them weave their tale and then write incredibly large numbers down on the verdict form. And those two things cannot coexist in a world where the statute is clear that it is EPA that regulates these chemicals. And I know you have all types of listeners, Harrison. Anyone who has ever reviewed EPA's review process, much less any registrant that seeks to go through it, it is a lengthy process that takes years of studies, review, and approval to get any chemical approved to go on the market. And then once that chemical is approved to go on the market, EPA has to review and approve the label that goes on it. This is not a quick process. It is not uncommon for a chemical to be under study and under review by the EPA for 10 years or more before they approve a new chemical to come onto the market. So anyone who is suggesting that there is a slipshod process that is overseeing what are the tools that our farmers need to grow the food that we depend on every day is just not educated themselves on EPA, its expertise, and how difficult it is to get any chemical through this process. And so given the amount of investment that it takes, the untold millions of dollars that they have to invest in these studies, not to mention the time to get a chemical approved, to allow state court juries in specially selected locations around the country to second guess EPA scientists on the basis of little to no evidence whatsoever, it's throwing the entire congressional statutory scheme into doubt. And so I'm glad that the Supreme Court saw that. I'm glad that they took the Solicitor General's suggestion that they hear this case. And I hope they'll listen very carefully to what Solicitor General Sauer and his team have to say as this case is briefed and argued, because this really could make the difference in between whether America is able to retain its status as the innovation leader in agriculture, or whether we potentially have a threat to lose that crown because we're going to let juries second guess PhD experts who've spent decades at this work.
In a moment, I want to get to foreign ownership. I just want to red flag that. We have about 20 minutes left, and I want to make sure we spend a few minutes on that. Another area that, especially I would say over, particularly the last 5 years, but 5 to 6 or 5 to 7, 8 years or so, that I personally have encountered increasingly is the world of antitrust and competition. There's and a variety, not necessarily one particular viewpoint. But it's an issue that has caught attention more and more. I just know that. I'd almost say empirically, but it's still anecdotal. It's just one place I've gone to the next and interacted. And so from a USDA point of view, and I should include into that specifically, but not only, right to repair. And so from a USDA perspective, what is the viewpoint on this? And I know there's quite a bit of action in this area, and just in general, like the status of it, what comes next, what's going on, and so forth.
Well, the answer on right to repair is clear and direct. This administration thinks farmers should be able to repair their own equipment, and industry's efforts to prevent them from doing so are illegal. That's why this administration's Federal Trade Commission is currently suing John Deere and some of the fellow equipment manufacturers to stand up for American farmers' rights to repair their own equipment and to not to have to suffer under a system where when their equipment breaks down in the field, they have to call a John Deere dealer, for example, and wait for them to send out someone to fix a simple issue that the farmer can repair him or herself, costing them time, productivity, and money. And that issue is symptomatic of a number of the issues that we're seeing. I mean, this is an administration. We come from a more conservative perspective. We believe in the free market, and we don't see antitrust conspiracies around every corner like some of our colleagues on the other side of the aisle do. Having said that, antitrust laws exist for a reason. And that reason is because when an industry gets too concentrated, that is to say, there are too few people competing, bad things can happen that undermine free enterprise. And there are signs that that may be happening in American agriculture. That's why President Trump has signed at least 2 executive orders asking USDA to work with the Department of Justice and the Federal Trade Commission to investigate these antitrust concerns. And one of them, as you've quite rightly noted, centers on equipment manufacturers. And it's not just the right to repair, it's the right to pick which dealer you purchase from. I mean, ask any farmer who's bought a piece of equipment recently. Can you pick which dealer you want to purchase from? The answer is no. I mean, if you were to ask the equipment manufacturers, they'd look at you, smile, and say yes. But what they wouldn't be telling you is that if you should happen to pick any other dealer than the one they designate as your local dealer, they'll charge you more for the same piece of equipment, the exact same piece of equipment. There's a financial penalty, which is prohibitive to your exercising choice over which dealer you use to buy your equipment, eliminating the ability to compete on the basis of price. And then once you purchase that piece of equipment, as you've rightly noted, Harrison, you don't have the right to repair it. You've got to have the implement dealer be the one to repair it. And when they do repair it, they will only use original manufacturer equipment parts, which cost more. So all of these 3 things, when added together, limiting your choice of where you can buy, And then when you have purchased the piece of equipment, preventing you from repairing it and preventing you from using anybody else other than their own parts, give them more pricing power and allow them to drive up the cost of not only purchasing the equipment, but of ownership and operating the equipment, all which goes directly to their bottom line. That's just one area. That's before we talk about fertilizer and the duopoly that is Mosaic and Nutrien, and their successful efforts over the past several years to constrain fertilizer supply in this country and drive up the costs that farmers are paying. Now, I'm happy to say, with regard to fertilizer, that Mosaic and Nutrien have been so lazy in regard to their own investments that they have actually enticed, economics seems to be working here, they've enticed a new private sector participant to come in, invest $13 billion of their own money in a new mine located in Saskatchewan, Canada, that next year in 2027 is going to begin exporting to the United States of America and break up that duopoly's control over how much can be imported in here. It should have never been allowed to happen in the first place, that those two companies were able to so constrain the supply of so many of the fertilizers our farmers depend on that they were able to get pricing power. And if you think that some of what I'm saying is not grounded in fact, let me just take fertilizer as an example. Mosaic and Nutrien have a joint venture in Canada where they openly, their word work together, my word collude, to control prices up there. That would be such a clear violation of the antitrust laws of the United States. They don't bring that joint venture officially down here in the United States. But what they've been able to manage to do through other means is achieving the same result, constraining supply and driving up the price that farmers pay. It's unacceptable. This administration is going to do everything it can to ensure that farmers have the fertilizer it needs to at a price that they can pay and a price that allows food to be purchased at a price the consumer can pay. And we're not going to allow these two companies to do anything to undermine this or any other new market participant that wants to come in, provide new fertilizer supply, and break up the cute little game that Mosaic and Nutrien have been playing for the last several years.
All right. Well, this is a good segue into the broader, just foreign ownership of agricultural land. And, by way of brief background, it's pretty well been an issue since even just predating the existence of the United States. You get into the Declaration of Independence and some of the issues there, this aspect of land ownership, and it's evolved, of course, over the last 200 years or so. In 2021, there was just a really ramped up attention, especially at the state level, on foreign ownership. It's an issue that we've covered extensively throughout all that time and up through present. There are many states that have modified their laws. They've enacted new laws. I think now we're at easily a majority of states have some type of restriction on foreign ownership, whereas in 2021, in the calendar year, super majority of states in the United States affirmatively allowed for foreign ownership, regardless of country of origin. That landscape's completely changed. I say that as background to a question that more focuses on the federal level. And we've seen more attention within Congress, but at USDA, I say a FIDA because I sound like I climbed out of a swamp, but the Agricultural Foreign Investment Disclosure Act.
Yes.
But I know there's a lot of attention there, and so like what's the latest with USDA on foreign ownership and where are we at there?
Well, an interesting fact that our national security team at USDA and across the federal government will tell you is that when it comes to certain countries' desire to own farmland in the United States, they appear to believe that the most fertile farmland is that located closest to America's military installations. And that, in a nutshell, is why we need to pay such close attention to this issue. I know you recall, Harrison, that back in the previous administration, a foreign company wanted to buy land in North Dakota near one of our critical military bases up there. And the previous administration claimed powerlessness to do anything about it. And so the city council of Grand Forks, North Dakota, had to step in and stop the transaction. Now, first of all, hats off to the city council of Grand Forks, North Dakota for doing something. I'm sorry they had to do it, but thank God they were there. But as a result of that, Congress stepped in and made the Department of Agriculture a member of the Committee on Foreign Investment in the United States when it comes to land transactions. And that's on top of the fact that since 1978, that statute you mentioned, AFIDA, the Agriculture Foreign Investment Disclosure Act, has required anytime a foreign person comes in possession of farmland here in the United States, they are required to register with USDA. Now, in all honesty, over the past nearly 50 years, that statute has probably been ignored more often than it has been followed. But if you read the text of the statute, it contains some pretty clear requirements, registration, and also some pretty severe penalties. It allows USDA to fine someone who fails to register their foreign ownership of agricultural land here in the United States up to 25% of the purchase price of that land. Now, what we're doing under Secretary Rollins' National Security Plan, which she rolled out on just my second day here, the 8th of July of last year, we're modernizing how we administer the Agriculture Foreign Investment Disclosure Act. We're going to make it easier for foreign owners of land to register by moving it from a paper process to a modern computerized process. It will also allow us to have better access to the records and be more able to accurately respond to inquiries from our fellow cabinet agencies as well as Congress about foreign ownership of land. But as a part of that, we're also going to get serious about enforcing those penalty terms, which means that if you don't file under AFIDA, you're going to get fined, and that fine is going to be substantial. So we're going to expect compliance as part of this. We currently have out for public comment an advance notice of proposed rulemaking. If you're watching this broadcast and you are a land broker or someone who frequently deals as a lawyer in transactions involving ag land, I encourage you to go to the Federal Register, look up the end of last year, around the 30th of December, I think it was, and take a look at that advance notice of proposed rulemaking. We've got an explanation of the policy ideas that we have, and then we've got a series of questions that we want feedback on from people who are involved in agriculture, who are involved in the sale and purchase of land, and the information that you provide us in response to those questions that we've put out in the Federal Register are very quickly going to lead to a new rule that we intend to propose and finalize this year that will modernize the Agriculture Foreign Investment Disclosure Act reporting and penalty regime. But we need feedback from all of the intelligent people who are watching this today, who are involved in these types of transactions every day, to help us be able to center in on what information we need and what the most efficient way for us to collect it is, so that this new regime can be a benefit and not a burden to productive agriculture here in the United States.
One thing I would add to that is keeping in perspective, we're talking about the Agricultural Foreign Investment Disclosure Act of 1978.
That's right.
So in this concept of modernizing it, and that was the first time the U.S. Congress in our country's history weighed in on this issue of foreign ownership. So I just wanted to highlight that, because oftentimes we talk about modernizing something, and it may, for this particular issue, there really is this is a significant, historically significant moment in how the federal government views this. So
well, and in some ways, Harrison, we're behind the curve, because as you know, there are a large number of states that have passed laws over the past 4 and 5 years affecting the ability of foreigners to purchase agricultural land in their states. Some states have gone with a total ban. Others have limited it to particular countries of concern. And your organization, the National Agricultural Law Center, has what I believe to be the best compendium of the current status of state laws available. I know when we at USDA want to know what the status of state laws are, we go to your website. And I have advised people at other federal cabinet agencies and elsewhere that if they want to know the best location for a compendium of these laws, it's your website. And it's the federal government that's behind the curve here. And we're supposed to be the people who have the best data on foreign ownership of land. We've fallen behind by ignoring this nearly 50-year-old statute. And under the Trump administration and Secretary Rollins' leadership, that's going to end this year.
So if we end up going a couple of minutes or so over, it's no big deal. Technologically, we're not going to get shut down. So, but we officially, we're in the last 5 minutes here. I am really interested, and I'm a little scared to ask it because it may not be fair. It may be longer of an answer than what we get to, but Prop 12, California's Prop 12, obviously that's not something USDA initiated or anything, but it's something that you would have to navigate. The Dormant Commerce Clause and the Supreme Court decision on that. Sort of interesting, and I'm kind of segueing back to your time as general counsel, putting your lawyer hat on. What do you think of that? Like, where are we headed in terms of litigation and how that all plays out? And I know there's likely to be efforts somewhere in the coming months in Congress to, as there have been in the past, to try to do some legislative solution to some degree.
So Harrison, I could talk for 20 minutes easily on this topic. I want to respect the time limits, but here's what I'm going to say. At the same time, our country is working diligently to knock down foreign trade barriers to American farmers selling their goods overseas. We have certain wrong-headed states on a number of issues trying to put up domestic trade barriers in our own country. This is nothing new. This internal protectionism by states is what led to the demise of our first Constitution, the Articles of Confederation. This is the exact reason that it failed. Because if residents of one state can block entry into commerce of products created by residents of another state, we're not truly one country. And that realization that setting up internal trade barriers was going to rip this country apart is what led to the Articles of Confederation being replaced by the Constitution that we have today. And the most important part of that Constitution was the Commerce Clause. The Commerce Clause gave power to Congress, not to the executive branch, not to the several legislatures of the many states, but solely to the federal Congress to regulate interstate commerce. And the Dormant Commerce Clause refers to the negative implication from that if the Constitution says Congress has this power, it means no one else, especially not the several states, have the power. So you can gather from my background here that I feel very strongly that the Supreme Court got that case dead wrong. Whether you are talking about the case from a civil procedure standpoint, or whether you're talking about the merits of the Dormant Commerce Clause issue, it would be difficult to get that case more wrong than the Supreme Court of the United States did. It resulted in a melange of opinions. It's hard to figure out which one is controlling, other than the fact that a majority of the court agreed we're just not going to do anything here. And they kicked it to Congress to solve. The problem with that is, from a legal perspective, I know this is a law center, so I'll get into law just a little bit. That case went up to the Supreme Court on a motion to dismiss. That's how it got up there. The case that they actually heard. I know there was more than one bubbling. On a motion to dismiss, as every first-year law student knows, you have to assume all facts pled in the complaint are true, and you have to ask yourself, is there any circumstance, assuming those facts are true, where the plaintiff is entitled to relief? When you look at what those appellate judges did at the Supreme Court in that case, They're having factual debates on a case that hasn't even made it to discovery, so there's no factual record for them to sort through. And you can only begin to consider facts on summary judgment. And if there are competing facts at summary judgment which are material, you can't decide it there. You have to go to trial. So the Supreme Court failed in its most elemental duty, which is to properly understand the differentiation between the role of the trial court, the role of the appellate court, and when and how facts come into play. That's before we get to the merits about the whole reason why we have a constitution is to stop laws like the state of California enacted through Proposition 12. But there's an important point that I don't want to be lost here and that I'll end on, Harrison, with regard to this question. There has been an effort by some to paint this opposition to internal trade boundaries that some of our states are throwing up as partisan. It is nothing of the sort. The Trump administration and the Biden administration disagree on a whole heck of a lot. But there was at least one thing that they agreed on. Both the Trump administration in term one, when I was general counsel, and these cases were pending before the federal courts of appeals, and the Biden administration in its term in office, when this case reached the Supreme Court, took the same exact legal position. California's law was unconstitutional and should be struck down. Now, how amazing is it that from the left and right, from the Trump administration to the Biden administration, people of many different policy views, different legal regimes in terms of whether they're originalists or living constitution type people, took a look at this statute and said, this cannot stand. And the Supreme Court gave the middle finger to us both. So I've recently seen in the press certain members of Congress and other people trying to turn this into a partisan issue. So if people get nothing else when it comes to these internal trade barriers, I want them to understand this is not a partisan issue, and anybody who's trying to claim that it is must have forgotten what the Biden administration argued before the Supreme Court, because it was exactly the same thing the Trump administration argued before the Ninth Circuit in its brief. And it's for one simple reason. If residents of Tennessee or Arkansas can't sell their goods in California or Massachusetts, then we're not all part of the same country, and we're back to where we were under the Articles of Confederation, and that's a problem.
All right. Well, I'll give you the last word. We'll wrap it up here. Is there anything that you want to throw out we should have covered and didn't? There were tons of things if we had more time, I'd get into hemp and Maha and some other areas, but we're running short on time. But any closing remarks that you'd like to offer?
Harrison, the one thing that I'll just say is the reason why the secretary, myself, all of our undersecretaries go out and talk to people is not to hear ourselves talk. It's to listen to what comes in as a result. One of the most common questions that I get is if I submit a comment as part of a rulemaking proceeding, if I interact with a USDA official, does that make a difference? And the answer is it does. Many of the questions that you've asked, I'll point to input costs as the most obvious example. Why is this administration, why are officials at USDA focused on this? It's because farmers and others involved in agriculture have told us point blank repeatedly, this is an issue you need to tackle. So I want to encourage, at a time of growing cynicism in our country, continued citizen involvement. This really is a democracy, and everybody in an administration, regardless of which political party, needs input from all of the people whom we serve so that we can make the best policy decisions and, equally as importantly, know what to spend our time focused on. So I hope your listeners will continue that interaction and that feedback with the USDA. It's absolutely vital.
All right. With that, we'll close. Thank you very much. I know you have a very, very busy schedule, and no doubt you're about to sign off and go straight into something else.
That's right.
We really appreciate your time and your energy here and everything you had to offer. It's very valuable. and we appreciate it very much. Thank you.
Thank you, Harrison.
Yes, sir. We'll see you.